Canadian Bill of Rights, which is an ordinary statute which in the 1960s codified a set of rights and freedoms. Now, this pre-1982 history is certainly not an unblemished one. It's part of a broader history that includes notable failures in rights protection, and so that needs to be acknowledged as well in discussing Canada's pre-1982 history. So that brings us to 1982 and to the Charter, which formed part of a package of constitutional reforms that included the recognition of Aboriginal and treaty rights and a domestic amending formula. So the Charter creates a catalogue of judicially enforceable rights and freedoms. Some of these rights and freedoms are a part of many constitutions around the world. So you'll hear us speak today about the right to to freedom of expression, to the right to equality, the right to vote, possibly. These are all core guarantees that are found in most bills of rights. There are other aspects of the Charter that are unique to Canada, and that would include, for example, the language rights provisions of the Charter. As Dean Leckie mentioned, the Charter is constitutionally entrenched. That means it's supreme law, and that laws that are enacted that are inconsistent with the Charter are of no force or effect. The Charter also prohibits state actors from violating rights, and so that means that state actors must conduct themselves in ways that are compliant with the Charter. And so that brings us to another important foundational point, which is that the Charter binds state actors. And what that means is that the state is bound to respect constitutional rights, but there aren't rights that are held as between private parties. Some of the rights and freedoms that you'll hear us talk about today include the fundamental freedoms, so freedom of expression, freedom of association, freedom of peaceful assembly. These are the core rights that are engaged in the context of a public protest. But there are also rights here that may not be immediately obvious, but which form an important part of the discussion. And so those include Section 7, which is the right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice, and Section 15, which is the right to equality. To the extent 10 of the Charter are also relevant. So what do these rights mean? How have they been interpreted? Well, the meaning of the Charter and of individual Charter rights has developed over the last 40 years, largely through adjudication in the courts, but also through the involvement and interpretations of political actors.
Maybe it's convenient that we're thinking of cars, but we could, of course, think of other vehicles as well when thinking about acts of expression. As Professor McDonnell earlier referred to, the court, though, recognizing the potential breadth of the scope of this right, has said that it doesn't include acts of violence. That's what they said initially, and then subsequently said, and it doesn't include threats of violence as well. So if an act involves, doesn't exclude advocacy of violence. I mean, that can be dealt with under Section 1 potentially, but from the scope of Section 2B, it only excludes acts that have the form of violence, so a terrorist act, some kind of physical violence directed at another, and threats to do so. All right. So the court has said that picketing, advertising, hate speech, obscenity are all fall within the scope of Section 2B, but of course are subject to reasonable limits under Section 1 of the Charter. I won't say anything more about Section 1 because it's been very well covered already. But maybe one thing worth noting is the court said with regard to freedom of expression, when we move on to Section 1 and considering limits, although all these different forms of expression are protected, some have more weight or more value than others when we are considering limits. So, for example, political speech, it's core value speech. It's closely, says the court, connected to the values that underlie our commitment to freedom of expression. And so it has a high value. It will be harder for the state to justify its restriction. On the other hand, hate speech, obscenity, commercial advertising are less directly connected to these values, and therefore it may be easier for the state to justify its restriction. Okay, I wanted to quickly talk about three issues, free speech issues, that might be worth considering. One of them is hate speech. And in Canada, hate speech is restricted under certain human rights codes, not all of them, and at the moment, not under the Canada Human Rights Act, but that may change at some point. And it's restricted, of course, under the Criminal Code, under Section 319(2), which prohibits the willful promotion of hatred against the members of certain identifiable groups. There are two kinds of harms that we can connect.
Park here and we'll bus you over to a different zone where you could gather.
Rights of trucks.
Wondering if you have thoughts on those.
Go ahead.
Okay,
Professor Moon will start.
I'll attempt that. I mean, I guess I have to preface any answer to that question with really what I think came out in our discussion, and that is people have the right to protest. Protest invariably involves some disruption of ordinary property use, and the question always is, what are the appropriate limits? And it's accepted that municipalities, for example, can put in place different kinds of restrictions, even notice requirements. If you're going to have a large protest, to inform the police or municipality in advance that you intend to do that. So I think the short answer is, I think they probably could do those things. They could say, no trucks parked in this area, no trucks can enter into this area. But it has to, notionally at least, be justified as a reasonable restriction on the right to protest. And certainly it strikes me, and this is easy to say in hindsight, that it could easily be understood as reasonable, given the amount of space, the pollution, the noise, and so forth that a truck could generate. So again, the real challenge, and I don't envy those who have to make decisions here around any of these questions, is that ultimately it is a very practical determination to decide how much disruption, how long, and so forth. And it would not, to my mind, be unreasonable to say trucks in a space like this is a significant disruption, and the protest can happen, but it's legitimate to exclude trucks from it.
Professor Moon, if I could just follow up. You were talking about reasonable limits and so on, which is evoking the idea of a limit prescribed by law and so on. Do you think like existing no truck zone bylaws or whatever form those rules take, would that have been enough as the legal basis for the police to interfere with what they perceived to be the exercise of the democratic rights?
Without kind of having a sense of what the array of existing rules are that could be drawn upon, I think the answer might be yes, but I don't know enough about what the bylaws would be.
You're hedging your bets a little bit.
I am, absolutely.
Yeah, thank you. Professor Mathen and then Professor Cameron.
So I think it's also fair to look to past practice, and it is true that in the past there were protests and assemblies that did involve trucks, but they did not stay. And that seems to have been part of the landscape in which law enforcement was operating, but there was also information indicating that they intended to stay. And so had they taken that to be a real statement of intent that would pose a different kind of enforcement problem, then I think that would be the basis on which you could absolutely seek to prevent that mode of assembly. Again, it comes down to what does the fundamental freedom actually entail, but certainly given the scale of the vehicles and the information that was widely circulating about what was the intent for those vehicles, at a minimum, yes, you could in that context reasonably restrict them from proceeding in the way that they wanted to.
Aside from those mandatory reporting thresholds, most of which have already been covered prior to the emergency measures, The new regulation of crowdfunding platforms requires these platforms to now file suspicious transaction reports. But in the context of a crowdfunding campaign, I struggle to see how these entities will report suspicious transactions, particularly when that reporting is limited to suspected money laundering or terrorist financing. As an aside, crowdfunding platforms are not widely used for either of these types of financial crimes. Instead, when we see crowdfunding platforms being used for this, or crowdfunding rather, it's primarily off-platform campaigns. So basically social media calls that are more widely used, which of course falls outside the scope of the regulations. And back to the issue of creating new reporting entities for FINTRAC, this means that FINTRAC now needs to ensure that they comply. Adding more reporting entities without significantly enhancing FINTRAC's ability to conduct compliance exams, for example, is a missed opportunity. Last year, the Centre completed 151 compliance exams, but there are tens of thousands, I believe 24,000 reporting entities. So this regulation might not have achieved much, further stretched FINTRAC's compliance function, and contributed to over and duplicative reporting to FINTRAC. And there is little point in creating more regulations without simultaneously enhancing FINTRAC's ability to ensure compliance. I'll move on to my third point, which is a little bit more about the unintended consequences and global implications of this. The international regulation of crowdfunding platforms. So since the convoy, there have been other calls for global standards to regulate these platforms as part of the global counter-terrorist anti-money laundering efforts. But these, again, are not based in much evidence of use of these platforms for illicit purposes, but instead represent something like more like low-hanging regulatory fruit. At a recent No Money for Terror ministerial conference, the host country, India, called for further regulation of the sector, something that Canada is now leading the way on internationally, for better or for worse. As countries and multilateral bodies continue to regulate more and more sectors under these global anti-money laundering counter-terrorist financing rules, it's important to keep in mind that there are plenty of unintended consequences of these efforts. For instance, authoritarian regimes often use these laws and regulations adopted to conform to these global norms to crack down on dissidents in their own countries. As my colleagues from the Royal United Services Institute recently noted, these laws are used for a number of things, including politically motivated pretrial detention, targeted audits, and asset freezes. Canada is now leading the way on regulating crowdfunding platforms, something that can easily be misused by authoritarian states, all under the guise of compliance with international norms. And that regulation has been adopted without consultation, public analysis of costs and benefits, or even an articulation of what it's meant to achieve. I'll move on now to the role of asset freezing seizures as a response to the protest. This is probably the most contentious element of the emergency measures because it directly targeted Canadians and their financial well-being without judicial authorization. The freezing of accounts and financial assets in Canada is usually done with judicial authorization. This is no small measure. When accounts are frozen, there are serious efforts not only for individuals directly targeted by the asset freezes, but their family, employees, and business associates. There are serious implications for individuals who might not be able to pay mortgages, child support, rent, groceries, etc. At the same time, when these measures are used in a targeted manner, they can be highly effective at encouraging people to cease and desist illegal activity and can facilitate a peaceful resolution. However, the way these emergency measures were implemented raises a number of issues. The main issue was in the identification of individuals whose accounts should be frozen. While the RCMP provided a list of
the presence of foreign funds. So it used to be charities had to disclose broadly how successful are your fundraising efforts, right? How much money did you raise? But now these particular ones in Canada now have to disclose the presence of foreign funding. So it's not a specific restraint, but it certainly is an exercise in opening up, in disclosing the presence of those, resources. So we've seen some of these. I think what's concerning about this to me was when I was originally looking at this, I thought this is going to be your usual suspects where we're going to see this, maybe some states that sometimes, at least in Western society, tend to maybe think they're a little bit troublesome. But none of these foreign restraints they're applying in the United States, in Europe, and in Canada. So it's in your reasonably well-developed democratic states that are imposing these restraints. And I would be remiss in not pointing out, with respect to foreign funding, that in July 2021, it saw the completion of an Alberta report, and the Alberta report deals specifically with foreign funding and the energy campaign and energy campaigns in Alberta. And it was an inquiry that was called in that regard. So that inquiry, there might be all kinds of other parts of that inquiry might be
for financing companies. So in a way, how is that different than raising funding for building a church or for organizing a group, etc.? So I'd like to hear the members of the panel, and Christian, please, raise your hand if you want to speak, in terms of what are the risks ultimately that we are talking about here, right? I mean, obviously, the fact that we are talking about foreign funding means that there is a risk. In terms of politics, as Jessica Davis mentioned, influence, undue influence over the political process is a risk, right? You don't want foreign states to influence democratic results in one way or the other. That's why we have rules over funding, etc. But what are other risks that are applicable here? So I don't know if anyone wants to go first. Jessica?
Okay, it's Jessica Davis. So I think you're right to argue that one of the risks is influence. I think another potential risk is compromise. So basically, the way that I see it is if an individual or an organization were to accept foreign funding that is probably intended to buy a certain level of influence with that individual or organization. But there's also the potential for the disclosure of that information to compromise their ability to do their job, or that they won't want that information compromised in the future, which in turn can also have another level of influence. But I think it's a good question. And I would also take a moment to talk about the foreign funding issue. I think, I don't want to be prescriptive here in terms of what should or shouldn't be in any kind of legislation about limits to foreign funding. I think that needs careful study. It's a very sensitive topic, but I think it is reasonable to start thinking about that in terms of limiting political activity. That might also have some limits to religious activity, because it's very difficult to separate these things out. I don't see that as necessarily a problem. I think that there could be a reasonable way of writing that kind of legislation to make that acceptable to Canada and Canadians, but it is a thing that it's something that we need to consider as we talk about that.
Quelqu'un d'autre? Christian? Ah, oui. D'accord.
Anybody else?
So it's probably helpful to differentiate between risk and threat, right? So everything's a risk in one way or another. But a threat is capability and intent. And so I think we always need to ask then, if we have actors who are providing funding, what is their capability in terms of actually influencing democratic institutions or whatever it might be, and what is their intent? And if the intent is nefarious, if the intent is to support illegality, criminality, if there's an anti-democratic intent, I think that would be an important sort of element of distinction. And so that seems to be driving, for instance, these foreign agent registries, that there's a particular concern that certain state entities have fundamental hostile intent and have the capability to follow through on that intent. And so you have to manage the risk very differently than, for instance, some donor, wherever, who's just giving money because she or he or they sympathize with a particular cause.
It kind of is, all right, it's a dispersal order that's not a dispersal order, so to speak. So it's kind of stretching the definition, I think, of notice, and it still doesn't really get around to determine whose assets get frozen. That remains a little bit of an uncertainty. And so that is where I think, from a procedural fairness perspective, it gets a little more complicated, unless you just view this as a quasi-legislative action, and then that's notice enough.
Patrick Leblanc. Christian.
Christian
Please.
Lebrecht. I think this really gets at the heart of sort of the challenge that moving beyond the invocation of the act is simply a means to an end, and it somehow had the effect, the strategic effect that that the public or the government was looking for. And I think so. These measures of notice then get us to, I think, 4 other sort of thresholds, which is, was it proportional? Was it necessary? Was it reasonable? And was it sort of and the efficacy, so efficacious, efficient. And so what does the sequencing look like in order to be able to then have on your matrix being able to check these off? And so I think the financial piece really came as a way to substitute for the relatively ineffectiveness of the initial law enforcement response, also on the financial side, because these financial investigations are some of the most complex investigations that you can possibly lead on a criminal enforcement, criminal intelligence side. And we're simply not postured with the people who can actually do these investigations. So we're having, I think, the conversation that we're having today as a way that the government substituted for the fact that we simply on the enforcement side didn't have the appropriate capacities and competencies if we had been able to leverage these the way other countries, Australia, the United States, France, Germany, leverage these in protests effectively, then we don't have to resort to these extraordinary measures. And so I think they're trying to understand, how do we get ourselves to some benchmark?
Said, because I think this is an important point in terms of the surveillance and what happens after, right? Once you've been designated either officially by some authority or unofficially by a bank within the context of the regulations or something else, right? And you said that there's always the potential that banks don't forget, that they will use this in their risk assessment of customers, either existing ones or potential ones. And I don't know, and this is open to everyone, but should there be some kind of process, whether, obviously it's in a crisis situations like the one that we experienced last winter, or if there is something in a way more systematic put in place where people should have some kind of appeal mechanism or transparency where they could look at their risk profile, or I'm not even sure if it's possible, but because I'm wondering, for instance, what if someone, and we know, participates in a protest and they do so, in with good intentions, to go back to intent that Christian was talking about. They take part in a protest, maybe things get out of hand, they leave, they might get designated just because they were there, and then all of a sudden they have, a sort of black mark associated with their names. Do we know if that black mark stays forever? Does it disappear? Does it have an impact? Is there any way of finding out? I'm just wondering, because you raise an important issue, and obviously then there can be associations. It's like, oh, well, these kinds of people participate in those kinds of activities which potentially could be nefarious to the state or the economy or something like that. And so I'm just wondering, is there a danger? And then what remedies or safeguards should we put in place, even if to deal with the situation, but then what happens afterwards? I'm thinking young people who demonstrate and might be arrested, and then they have, some kind of record that affects the rest of their lives, even though, they might have changed their lives.
Folks, if you want to be kept up to date on what's happening at the Emergency Act Inquiry, including my live tweets and some clips and highlights that occurring at the Emergency Act Inquiry, by heading over to revolutionnews.ca/Emergency Act Commission. That's revolutionnews.ca/Emergency Act Commission. And of course, here, folks, while you're there, please head over to donorbox.org/Emergency Act Commission. That's donorbox.org/Emergency Act Commission. And of course, here, folks, if you could chip in a buck or two, that will be greatly appreciated, as it will help me cover my travel expenses, including my expenses on food, as bringing you these stories doesn't come for free. Thank you so much.